Good afternoon, ladies and gentlemen. The next two speakers, I'm just going to introduce those. I'm going to take up as little time as possible in this regard. We've got some very interesting contributions to our conference, which are just about to be made. Now, the first of these is a former colleague of my own, Dr. Blathna Ruane, who has a PhD in constitutional law from Cambridge University. She was called to the bar in 1992. She was, until that time, I think, he was practicing solicitor at McCann Fitzgerald's in Dublin. And in 2009, then she was called to the inner bar. She's a distinguished writer on legal matters, particularly on the Constitution, law and government. She's an adjunct professor of law at the Sutherland School of Law at UCD. Dublin, and was a member of the Constitutional Review Group 1995 to 1996. Our other speaker today is Erskine Childers, who is the great-grandson of Erskine Childers, the secretary to the delegation in London, and of course the grandson of President Robert Erskine Childers, President of Ireland. Erskine is currently working on a book on Erskine, on the lives of Erskine Childers and his wife Molly Childers, and that book is nearing fruition, as I understand it. He has a career in advertising, and he lives with his wife and son in the United States. I'm going to ask Blathna to start, and we'll take questions for the speakers after Erskine has delivered his paper. So I'm not going to take questions immediately for Blathna after she's delivered her paper. Blathna, over to you.
Well, thank you to everybody for having involved in organising the conference, for the invitation this afternoon. My hope this afternoon is to give you some insight into the legal complexities that were involved and associated with the Anglo-Irish Treaty and their long-lasting impact. This audience particularly will be familiar in general terms with the Anglo-Irish Treaty, its provision for Irish Free State Dominion status, Canada style, but with extra restrictions imposed that weren't applicable elsewhere, the oath of allegiance, the right of Ulster to opt out, an Irish contribution to the public debt, defence arrangements, retention of British access to Irish ports, maintenance of an Irish army, religious freedom, and transitional arrangements. Now, instead of looking at those in detail, because they've been examined already here and elsewhere in some detail, what I would like to focus on instead are the legal implications of settlement for Ireland's long-term legal status, and particularly it's having been done through the legal mechanism of a treaty. And the first thing I think to note is that previous attempts at settlement of the Irish problem from 1886 onwards were effected through or attempted through internal constitutional arrangements by Westminster legislation, provided by a statutory grant of limited powers. They were in the nature of devolution settlements in which certain restricted powers were to be granted to a subordinate legislature. The grant was made by Westminster Parliament, and the scope of the operation of the subordinate Parliament was to be limited. Westminster retained ultimate control, and significantly, what they granted, they could take back by future legislation. The future security of any such settlement was thus ultimately in the hands of the Westminster Parliament. An enormously important aspect of the settlement of 1921 from a purely legal perspective was that it was made by means of a treaty. A treaty was well understood by that time as an agreement between two countries, which were separate and distinct states. Treaties are usually negotiated and signed by plenipotentiaries and are later ratified by the national legislature through national legislation. By July 1921, Lloyd George was under pressure to grant Dominion status to Ireland, which he had hitherto resisted. Dominion status involved allegiance to the king as the head of the empire. Dominions were self-governing and had far greater powers than what Home Rule would have given to Ireland. But even they were not fully sovereign, and they remained subject to certain imperial restraints. The legal mechanism for creation of Dominion self-government was rooted not in treaties, but on a British statutory grant of rights. Starting in the mid-19th century with Canada, by 1921, Dominion powers had evolved considerably, and they had reached the point whereby it was held in many important circles that Dominions could probably succeed from the empire. That development had been hastened by the Dominions' ongoing political evolution, their geographical distance from Britain, and also by the impact of World War I on their relations with Britain. Britain depended enormously on them for support in the war, but the impetus for greater Dominion control had grown due to their own natural demands also for control in how the war was fought, and they began to become involved in imperial war cabinets during the war. So by 1921, the real or de facto powers of the Dominions were greater than their formal or de jure statutory rights suggested. Dominion law was unclear, due in part to resistance from within some of the Dominions themselves to delineating it precisely. Now, following the truce, when he met Lloyd George in London in July 1921 for exploratory talks, De Valera demanded a treaty as the legal mechanism for any settlement that might be reached that would recognise and accept Ireland's independent status. That was conceptually entirely consistent with the way in which Sinn Féin was already operating, as if Ireland was an independent state through its Dáil Ministry, the Cabinet, and the Dáil court system. A treaty was also sought because Sinn Féin feared that any settlement made through British legislation might be reversed by them. The idea was that Britain would have international treaty obligations which would prevent them from reneging on the terms reached. Now, towards the end of the July negotiations, Lloyd George decided to make his best settlement offer, even before formal negotiations began. He offered restricted Dominion status, but significantly, he offered it through settlement by the mechanism of a treaty. The offer to deal with Ireland through entering into a binding agreement by means of a treaty carried with it an inherent recognition at the time of its making that Ireland was a separate state. That approach ran directly counter to long-standing British theory of Ireland's legal rights as being an inherent part of the United Kingdom itself since the Act of Union. Lloyd George's proposal to offer a treaty was startling. In fact, it was maverick. And when it had come before the British Cabinet prior to making the offer, predictably, it had met with considerable opposition and was described as having caused a lot of heartburning. There was British Cabinet concern about the use of the term treaty because it would be a dangerous precedent for India, which had been a major support in the war, but which, despite British indications it might happen, had not yet attained Dominion status. More critically, it was a concern because it involved recognition of the Irish Republic, which would be a problem for the type of settlement that could be reached, and of course, in the event that the negotiations broke down. The proposal was only accepted because of Lloyd George's statement that the Irish had insisted on it, and because of his references to other treaties with Scotland, South Africa, and the Treaty of Limerick. In reality, those were not comparable analogies within British legal theory because of Ireland's status since the Act of Union as an inherent part of the United Kingdom. Despite having offered to deal by treaty, Lloyd George still attempted to adhere to the British rejection of Ireland's claim to independent status. He spent August and September of 1921 corresponding with De Valera on whether negotiations could take place, and in the course of which he explicitly denied Ireland's independent status. That denial continued throughout the formal negotiations, but the British continued to accept that if a settlement was reached, it would be by means of a treaty. There was thus an inconsistency, or perhaps a strategic ambivalence, in Lloyd George's negotiating strategy regarding Ireland's legal status. Another view of his legal strategy, taken later by several senior legal figures, was that he was changing the internal constitutional British arrangements in a way that was unconstitutional because it was without full parliamentary scrutiny. By proceeding through a treaty mechanism, negotiations could be conducted by the British government negotiators alone, directly with the Irish representatives, thrashing out the terms to the point of a concluded agreement, with no other party intervening in the negotiations unless requested to do so, as obviously happened in relation to Sir James Craig. The treaty process thus rendered the negotiation process more secret. They were thus spared the ongoing public parliamentary process of consideration, argument, bargaining, and revision of draft legislation in a public forum. Only when a concluded agreement was reached and Lloyd George was satisfied with the terms would the British government be obliged to go to Parliament to get approval and ratification. Of course, the substance and details of the treaty could be commented upon or criticised in the ratification legislation debate, but the detail could not be redrafted through amendments, as would happen normally with ordinary legislation. It would then give Parliament only a take it or leave it choice over whether to accept the terms of the treaty. Redrafting would not be an option without Irish consent, which was readily understood as likely involving the collapse of the settlement and indeed of Lloyd George's government. Lloyd George thus got the negotiating benefits of the treaty mechanism, and he also gave the Irish negotiators what De Valera had demanded. While offering Canadian Dominion status, Lloyd George also demanded acceptance of various additional terms, such as relating to defence, finance, trade, etc., so that the offer was not straightforward Dominion status, but a lesser version carrying additional restrictions. By having the additional obligations made the subject of explicit treaty obligations, it gave a second basis for Irish compulsion beyond anything flowing from inherent Dominion status. For the Republicans, settlement by means of a treaty, which implicitly recognised Ireland's independent statehood and which could not be altered unilaterally by later British legislation, was a major breakthrough. The sting, however, was that they could only get that treaty by accepting a simultaneous downgrading of that independence to restricted Dominion status. Another problem was that even if other dominions could later secede from the Commonwealth, Ireland might potentially be prevented from doing so by their separate treaty obligations. The Irish resisted strongly the British core demands for allegiance to the Crown, including the oath and acceptance of Dominion status. Instead, in return for essential unity with Ulster, the Irish eventually put themselves forward as willing to accept what was called external association, whereby Ireland would be an independent state which had an association with the British Commonwealth over matters of concern, such as defence, but they would remain outside the Commonwealth and the British Empire. This was an idea that had been put forward by De Valera to Lloyd George in August after he'd rejected Dominion status. The negotiators were also prepared to accept a very watered down oath, which included recognising the king, but only as the head of an external association and by no means as head of state. That offer was completely unacceptable to the British. They could not contemplate such a relationship that refused loyalty to the Crown and membership of the Empire. Essential unity was not being offered either. Ulster could opt out, and the Boundary Commission offered an uncertain outcome in yielding unity later. The issue of legal status was always going to be a crunch point, and it had been staved off and only came to a head towards the end of the negotiations. Under British threats of war, the Irish negotiators reluctantly conceded the British draft with some minor amendments and some perhaps maybe more important amendments, but nothing touching the overall status issue. And the overall agreement, very similar to what Lloyd George had originally offered the previous July, was signed. The title was Articles of Agreement for a Treaty between Great Britain and Ireland. It was signed by what were described simply as the members of the British and Irish delegations, carrying no reference to plenipotentiaries. The treaty had then to go through an approval and ratification process on either side, and as such was going to depend in part upon a British Act for it to become effective. Legal issues regarding the treaty mechanism arose immediately on both sides in the effort to have the agreement approved. In Britain, very senior legal figures, including judges, senior judges in Parliament, challenged the constitutional validity of making what was termed a so-called treaty with what was, in British legal theory, a part of the United Kingdom. The objection was that the United Kingdom could not make a treaty with a part of itself or with individual subjects of the Crown. It was furthermore argued that Lloyd George's procedure was unconstitutional because any regional arrangement could only be an internal constitutional agreement, which would have to have been subject to much more stringent parliamentary scrutiny. In Ireland, debates over the treaty were particularly bitter. De Valera challenged the validity of the agreement, saying that the plenipotentiaries were not entitled to sign without reverting back to the cabinet of the second Dáil, and that the Dáil members could not approve or ratify the agreement because it was ultra vires, beyond the powers of the Dáil, which was bound to uphold the Republic and could not deviate from that. The treatyites said that the plenipotentiaries were responsible to the Dáil and not the cabinet, and asserted that the agreement was to be an international treaty under which Ireland, as a separate state, accepted Dominion status and was a stage on the road to achieving a republic. Anti-treatyites also attacked the treaty because the constitution, which had yet to be drafted and accepted, would be regulated by the British Act and would derive from a British Act. The treatyites argued that the constitution would derive from the Irish people and not from any act of the British Parliament. There was also uncertainty over what version of Canadian Dominion status had been obtained, and in particular, whether Ireland had obtained the important benefits of Canadian de facto legal status developments up to 1921, or whether it was confined to the much less satisfactory earlier Canadian de jure status. De Valera wanted the treaty to be rejected by the Dáil and wished to resume negotiations and to put forward what was called document number 2 to the British. That document, in essence, was a restatement of the external association formula, which had been previously agreed by the British, and his proposal failed. Because of the majority political support for the settlement on both sides, those serious legal issues remained just what they were, unresolved legal issues, but they didn't actually prevent approval on both sides of the Irish Sea, in Britain by large majorities and in Ireland by a smaller majority. The hurdle of the legislative ratification process still remained, with plenty of scope for the settlement to come undone, particularly as it took place against the backdrop of increasing Irish tensions and the outbreak of civil war. The first step in Britain's legislative ratification was in March through the Irish Free State Agreement Act. Throughout the debates, Lloyd George's tactics of continuing to categorise the agreement as a treaty were seriously attacked as changing internal constitutional arrangements without proper parliamentary scrutiny and preventing debate. Nevertheless, the bill passed. The Act, as a matter of British law, gave the agreement the immediate force of law. It provided for the transfer of powers for a provisional government, part of which had taken place in January, as provided for under the treaty. It also provided that the elections were to be held as quickly as possible to create a new parliament, which was intended to adopt a constitution. The Act provided that the Ulster month, during which Ulster could opt out, would not start to run until a later British Act was passed adopting the constitution. This was to enable Ulster to see the Free State Constitution before making its decision. Meanwhile, the treatyites had prepared a draft constitution which they hoped would limit British control further. But the British rejected it in May and early June as a republican constitution, and the British threatened military action. It was quickly redrafted to render it consistent with Dominion status. The revised constitution was made public immediately before the election of the 16th of June. The election resulted strongly in favour of the treaty-ite candidates, but it was not actually a plebiscite on the treaty or indeed on the constitution. In October, the Constitution of the Irish Free State was passed by the new Irish Parliament, or Third Dáil, which was sitting as a constituent assembly, to enact a constitution and to implement the treaty. That act was framed so as to maximise the basis for claiming an indigenous Irish authority for its adoption. However, it also provided that the constitution was to be construed in accordance with the treaty, and it scheduled both the constitution and the treaty. It also gave the treaty the force of law and was therefore regarded as being the Irish legislative ratification of the treaty. The final British legislation was not passed until early December, and even at a very late stage, just before that, there was concern as to whether the final British legislation would actually proceed. Lloyd George, who had spearheaded the agreement, fell from power in October and was replaced by a Conservative Unionist government with Bonner Law as Prime Minister. In the event, British public opinion was such that the Conservatives decided not to try to unpick the treaty that Parliament had approved twice already, and with civil war raging, the legislation was given the final imprimatur by the British Parliament in early December, on the strict basis that it was a Dominion-type constitution within the four corners of the treaty. The Irish Free State Constitution Act was passed by the Westminster Parliament on the 5th of December. That act deemed it to be the act of ratification of the treaty for the purposes of the Ulster Month. The last step was taken the following day when the Royal Proclamation was issued. The British thus retained control until fully satisfied with the Free State Constitution. Settlement by treaty had greatly facilitated getting approval for a settlement in Westminster. Lloyd George's stage management of the approval and ratification process effectively went through the motions of parliamentary oversight, but in reality allowed no amendment of its terms and thus bypassed much British controversy. The treaty settlement came before Parliament on a take it or leave it basis as a done deal, tucked away in schedules to the acts, rather than set out in the main text inviting unionist amendments. The treaty could not be renegotiated line by line in parliamentary debates. This was a very different process to the parliamentary trench battles of earlier settlement attempts. The negotiating dynamic in 1921 was also different because Sinn Féin would not participate in Westminster parliamentary debates. So there was no John Redmond there to articulate an Irish nationalist viewpoint in that sense. Like Lloyd George, the Irish side had benefited from being able to negotiate directly and from being able to put a take it or leave it deal to the Dáil. Negotiations between two parliaments would not have worked in the circumstances. Settlement by treaty did not, after all, avoid British legislation, but for the treatyites, it did at least fix the terms of the agreement, unless alteration was jointly agreed. Apart from facilitating the reaching of a settlement, the treaty mechanism also boosted the treatyite view of the Free State's indigenous root of title. It bolstered their assertion that Ireland was indeed already independent and that its independence had been recognised in the very instrument of settlement. That was a symbolically important achievement, despite the huge anger at the other elements of the treaty. Although they were also compelled to have their constitution approved by the British, the treatyites had ensured that the various legal steps required for the approval and ratification of the treaty and its adoption of the constitution were carried out in Ireland in a manner that was consistent with that assertion of independent statehood. It had required very careful legal choreography. Whilst Britain could claim that the creation of the Free State and the Irish Constitution were creatures of a British Act of Parliament, the treatyites could counterclaim that the settlement was by treaty and the Constitution was actually adopted by the Third Dáil, whose legal title went back to the Declaration of Independence of 1919 by the First Dáil. Their argument was that it was an independent Ireland that had accepted the treaty and the compromise of Dominion status as well. That it was a real treaty was recognised by its implementation by the process of approval and ratification. The state's root of title was thus not based on British legislation. Confirming that, the Free State, against British opposition, succeeded later in registering the treaty with the League of Nations, again bolstering its credentials as an international agreement. Lloyd George's negotiating strategy was maverick, it was opportunistic, legally inconsistent, and unprincipled in many respects, but had actually proved to be an important element in reaching a settlement. And paradoxically, along the way, it vindicated De Valera's demand for settlement by treaty back in July 1921 in asserting Irish independence. Now, looking forward very briefly to what happened subsequently, the formal negative legacy of the treaty on issues to do with Irish legal status and the fact that it still was not a fully independent sovereign state took a generation to remove. In the 20s, pressure grew for confirmation of the independence and equality of the dominions, a process in which the Irish Free State played a leading role. It led to the Balfour Declaration in 1926, which declared the equality in status of the autonomous communities within the empire, in other words, the dominions. That led in turn to the Statute of Westminster in 1931, which confirmed the legislative independence of the dominions. The gains made through the Statute of Westminster facilitated the various legislative changes made by De Valera after he got to power in 1932 in dismantling piece by piece many of the resented elements of the treaty associated with status and taking no further part in the Commonwealth. He would, of course, not wish himself to be seen to rely on the Statute of Westminster, but the truth was the Statute of Westminster had a negative effect on Britain's willingness to make a huge controversy out of what he had done. His new constitution of 1937 was that of a republic in all but name. For the Commonwealth, pressure from India and the pressures provoked by the Second World War prompted more change. In 1947, India became a dominion, and in 1950, she became a republic with the president as her head of state, but she remained in the Commonwealth. She accepted the king as a symbol of the free association of its independent member nations, and as such, the head of the Commonwealth. In that transition process, De Valera's idea of external association had provided some pivotal inspiration. India's advance to a republic had prompted the London Declaration of 1949, whereby for the first time a republic could be in the Commonwealth, and which continued to, and continues to this day, something which was utterly unthinkable to the British in 1921. By then, of course, attitudes to empire and nationhood and statehood had changed, and Britain by then was in no position to prevent that development, even had she wished to do so. Ireland herself became formally a republic through the Republic of Ireland Act 1948, even though her constitution from 1937 was in many ways a republic in all by name. So by 1948, approximately a generation later, the difficult legal journey to sovereign statehood finally had been reached by Ireland. She got there eventually. Thank you very much.
Lorna, thank you very much for that most interesting contribution to our to this conference. And I'm just going to go straight now into Erskine's paper, if I may. Erskine, over to you.
Thank you, everyone. Good evening to all in Ireland and the UK. I get the task of rounding out day 2 of the conference, which has been a rich examination of a very complex and difficult time. I have huge love for Cork County and have spent holidays there way up into rebel country along the Macroom Road. If you've never seen Ballyvorney in a good fog and rain, you haven't seen enough. Get up there. I couldn't start without thanking Cork City Council, Cork County, the UCC, President O'Halloran, Dr. O'Driscoll, Dr. Borgonovo, and Dr. Dougherty for my invitation and for bringing us together in this esteemed venue. I view Dr. Joe Lee as an historical mentor of sorts. His book, Ireland, 1912-1985, was one of the first that I read as a teenager, and it remains proudly in my library today. I'd like to also show gratitude for the long hours of work put in by Wally, Carol, Ronan, Richard, and those in the Descendants group for taking this event to the finish line. It's been a pleasure to be involved with such distinguished company, and our forthcoming book will be historic. Finally, I must thank Taoiseach Martin and Ambassador Johnston for their engaging and thoughtful words at this very intense time between these islands. Your presence here at this conference is indicative of the poignancy that 100 years can bring to how we navigate through the burdens of history and how we try to reconcile all the previous lives that have been lost in the balance. I personally have been reminded to my face in unpleasant realities of just how far the memory goes in the North, about the border and about the treaty, when attempting something as simple and routine as paying a bar tab with my name on a credit card in, let's say, Belfast. Quote, "Your custom isn't welcome here, Mr. Childers. The door is right over there." Needless to say, ever since I've settled in cash when across the boundary, lessons learned. Of course, these moments of tension are small in comparison to much more dangerous divisions faced daily by so many. But there is still a lot of fractured families on all sides that have never had closure from the 1920s. I know many of their stories and have spoken directly to those with open wounds, grandparents weeping quietly about, quote, "those days," unquote. Let us never forget these families. And as we head into the most difficult of remembrances and commemorations next year, let us keep focus on the 100-year national trauma that is ever present and generational. Ignoring long-standing trauma is expensive. It does no society any good. Trauma can't be negotiated. Trauma doesn't know borders or checkpoints. Proof of this is glaringly obvious in the recent commemoration planning at an infamous castle in Dublin. We have an opportunity to help people through these next coming years. Let us embrace that challenge to help people along the way. As our President Higgins says so well, ethical remembrance. At this point onwards, I want to say that these words and thoughts that follow are not representative of a family opinion, but solely my own. The group of descendants, many of whom you have heard speaking earlier today and yesterday, agreed from day one that in order for this event to be successful, it must be apolitical. And although there could be a 7-day conference on the undercarriage and enigmas of the treaty and all its seriously controversial aspects that played out in those months between our islands, this is not the place nor the time for any of that. The treaty has been dissected, torn apart by pundits, put back together by historians, dragged through the heights of whataboutery by every faction and every side. Yet nobody has dealt with the public service involved. The idea that these men and women, not perfect, all with flaws and pride, decided to put their names on the line for something bigger, for a chance to change the direction of a country, to break away from a colonial box. What we know of the Anglo-Irish Treaty of 1921 is based largely on primary sources of information. The, quote, Childers Papers, unquote, at the Library of Trinity College, Dublin, is one such source. Erskine never got the opportunity to give his own views of those months in the negotiations and beyond, which is sad. As you can count on one thing, it would have been beautifully written. Perspectives abound, though. The main books like A Doyle Girl's Revolutionary Recollections by Kathleen Napoli McKenna Peace by Ordeal by Lord Packenham, or Whitehall Diary by Thomas Jones, gives some wonderful overview of the process and the administration, but don't reveal everything, and certainly omit some facts that are critically important. I must stress that very few of the Irish treaty delegation themselves wanted to comment or speak directly on what transpired. Of the plenipotentiaries and secretaries, Collins, Griffith, and Childers had all passed away soon after the treaty. The three did make their views publicly known before passing, but without proper memoirs, what we have is just the political exchanges and not the context. These men had biographers, some good, some terrible, but without their own hands on their papers, a lot is left to conjecture. Robert Barton's treaty papers were given in entirety to Lord Packenham, and then to the National Library after that. Duggan essentially avoided the topic and talk of it completely from what is known. Gavin Duffy, as our Taoiseach mentioned this morning, had the most extraordinary views on the treaty. And I would go further to say that his influence on Irish civil law, for example, remains with us to this day. Any of the tier 1 solicitors and even judges in this venue presently can attest to that. John Chartres only publicly shared his views of the treaty once in an article about Michael Collins, shortly before his death. One of the most fascinating books on the treaty is the Murphy book on him, which I encourage all to seek out. Let me say the phrase again, quote, "what is known," and make a plea to those who may be watching. If there are relatives out there who have these direct sources of information, let's say in a suitcase upstairs or in a biscuit tin in the closet, please do us all a favor. Get them to one of the many institutions that can preserve them, or in another way, to one of the many auction houses. Regardless of what they contain, they are now the history of our country and will help us make sense of a storm of a decade. The Erskines before me came from a long line of civil and public servants. To my count, recently, 9 direct generations going back. Great-grandfather Erskine was a fascinating man. He was a man of conviction, with a brilliant mind and an extraordinary literary gift. His jump towards Irish republicanism at the end of his life is easy to frame up when you consider one of his most passionate topics. He believed in home rule his entire adult life. This is not generally known about him. At Cambridge University, there are records of him defending home rule in debates from the age of 20 years old. This is the 1890s I'm speaking of. It would be home rule that later broke his heart after the failure of the Irish Convention in 1918, leading him not only to turn his back on a near 20-year career of both writer and parliamentary clerkship, but his reputation, his London friends, and family all at the same time. His move permanently to Ireland in 1919 was precipitated by a sense of duty to help it finally achieve self-governance and independence. Ironically, it would be this sudden move out of a genuine passion that created the spy allegation that dogged him over the last 3 years of his life. On a page of clear acetate in handwritten blue wax pencil at the National Maritime Museum in Greenwich are the following blunt words, sent to my namesake at Harn's Place, undercover. The blue wax pencil in 1921 and the acetate it was written on were common tools of newspaper editors, and Erskine knew all of them in London. Quote, journalistic friends in London for whom you have done work desire to warn you on unimpeachable private information that you are being watched and in danger of arrest as a spy. Destroy this. My grandfather, President Childers, died suddenly without a memoir and without really publicly speaking about his Anglo-Irish childhood in the 1920s. So in some respects, there is a decades-long cumulative historical family void, a traumatic void that several biographers have tried piecing back together, a story within another story. One of the chairs that is unfilled in this great hall where you are all gathered when we speak of the treaty is that of a member of the De Valera family, which would of course be welcomed by me at any point in the future. I now ask that you permit me to share a special letter from my grandfather, TD, and former president in the park. It's a private letter from him giving permission to my father to give a talk on his mentor and dear friend for the BBC radio. My father, then a journalist there. From one Erskine to another, father to son, about De Valera and the treaty, on green harp, Doyle stationery, I hope you can see that, on the 8th of June, 1965. I will just excerpt the relevant, and don't worry, this won't be put back in the biscuit tin, in my shed. It will eventually be donated. From my research, this is the only known comment from my grandfather on De Valera and the treaty, public comment. Dear Erskine, I imagine that most holidays are booked for August in the British Bay Area, but there is no way of finding out, save by advertising in the Independent or the Irish Times. I see no objection, whatever, to you preparing a half-an-hour talk on Dev. The main thing is to make sure that the issues at the time of the treaty are fully understood. At the end of the negotiations, as you know, Dev was quite prepared to now virtually Dev was quite prepared to accept an association with the Commonwealth of a kind which is now virtually universal, with the exception of the older dominions. This was not accepted by Lloyd George and the English delegation. Then again, it is terribly important to point out that De Valera did everything he could to prevent a civil war by establishing a pact with Collins, whereby the issue of the treaty was to be postponed for the time being and the country governed in a way which would prevent civil war. I think civil war is best treated as a Greek tragedy, an event which was almost bound to have taken place if Mr. De Valera himself had not taken the firm stand which he did at the end. It was simply a conflict between people who were inspired by the 1916 Rising and those who previous to that had been home rulers and who felt that the treaty offered a means of advancement in the future. I think the next point to take up would be the irony of the situation created by the fact that Mr. McGilligan and Desmond Fitzgerald fought at the Imperial Conference in 1924 for the Statute of Westminster, which was later passed in 1931. When Mr. De Valera took office in 1932, he gradually removed the Crown clauses in the old Constitution and established a new Constitution within the Commonwealth through the External Relations Act, to which all Irishmen could subscribe. His decision to enter Parliament in 1927 to agree to a form of link with the Commonwealth, which in those days was completely novel, indicated his belief in the present Commonwealth principle. I think it very essential to mention the fact that never for any time did De Valera propose the use of force as a solution for the partition problem, and that even at the height of the Anglo-Irish War of Independence in 1921, he publicly stated that physical force was not contemplated. His statement then has now been taken up in far greater reality through the decision to find matters of common concern with the people of the North. Love Erskine. Erskine to Erskine. We've heard many Erskines today, so another two. Families and indeed widows of public servants know all too well the issues of privacy and public service. In Japanese culture, they call this special toil amote ura, the public face, and then the private face. The men and women of the treaty delegation knew this all too well. As Carol Fawcett mentioned this morning, the plenipotentiaries were all subject to daily threats. Daily envelopes left in the door at Hans Place, phone calls by unknowns, an unshot bullet left on the door sill in Dublin, all sorts. Doyle memorandum, diaries, and ministerial letters give you an incomplete picture of someone's service to their country. They generally give you the outline and timeline, but they seldom penetrate the surface. My first cousin, once removed, Robert Barton, in the years after the treaty, right up until the 1970s and his death, consistently avoided discussing it with nearly everyone, except for a rare family conversation here and there, and if then only briefly. My father, in his unpublished memoir written 5 years before his death, describes the following scene from a visit to Barton in the 1960s at his house in Wicklow. The quote Bob mentioned here is what he let close family call him. Quote, I walked alone with Bob up the bleak hill behind Glendalough House. I had not planned to, but something made me simply ask him what that moment, that night in London was like. And I remember instantly feeling foolish to have framed such a question, if embarked on an enormous question like that at all. Bob said, quote, Erskine, you know I never talk about that, unquote. And he said nothing more about anything for a long time as we tramped up over the short grass and heather, further up the slope. Then he stopped and turned, facing down the mountainside, and said, quote, did anyone ever tell you that your grandfather Erskine loved the view from here? Unquote. I thought of him, and I thought that this was the end of it, and his way of changing the subject. Then I heard that strong, reticent man sigh and say in his high-pitched voice, quote, I will not talk about it, but it was much, much worse than if Lloyd George had held a gun to my head, Erskine. That would have only threatened me. The gun he held pointing at me was pointing at all of Ireland, unquote. An American journalist called Peter Golden was one of the last to interview my great-grandfather Erskine, some 50 kilometers away from this building, in the fall of 1922. This would be only weeks before his execution in November of that year. This is an excerpt from that book, Impressions of Ireland. Quote, it is said Childers knows more intimately than anyone else all that transpired at the various conferences in London between the Irish delegates and Lloyd George. The vendetta of hate has been deliberately set going against him by those who are not anxious that these revelations be brought to light. Childers tells me that he doubts if any event in Irish history were ever so thoroughly documented as the proceedings in London. I ask, quote, are those documents safe, unquote. He says, with a shrug of his shoulders, quote, I have made all possible efforts to have kept them safe. And to make things more complex, of course, is when the weight of his heritage was used against him in the Doyle, the damned Englishman, unquote, the insult given to Erskine by Arthur Griffith during the treaty debate in 1921, also forever enveloped him in not being Irish enough, not being English enough, not being Republican enough, misunderstood in Ireland, misunderstood in England. A lonely moment, you might say, but one that he stood up to with pride. Erskine was absolutely fearless. And when it came to questioning what he considered being of service, at those times he was stalwart. He remained so until he was shot by Irishmen, or rather, judiciously killed. As we look back at a century of modern Irish history, it is important to consider what civil service in 1919 to 1921 meant for a burgeoning new underground government, one of the youngest such governments in Europe. Historian Dr. Kennedy, in his benchmark essay, quote, civil servants cannot be politicians, unquote, from whom we heard from yesterday, has called the Sinn Féin government of 1990, quote, a tragedy. In that, it was in essence the foundation stone of a traditional civil service that would be fractured by the treaty itself 2 years later, only to then be put back together after the 1922 handover. Lives by then lost, friendships destroyed, towns became battlegrounds, and religious animosity exploding. Recently, in these last years, we have all witnessed that the world has become more geopolitical, more extreme, more tribal, that treaties, articles of agreement, referendums, and even elections have been laundered by gamification. The media is increasingly pure entertainment, and critical journalism is continually seen as old-fashioned or stuck in platitudes of the past. People will pick up a newspaper in the train station for free, but won't pay for a real newspaper. As AI continues to influence trends in communication, this will only get worse. And my friends, automation is coming for all of us. But I digress. This paper was only meant to give you a glimpse into 1921. But what I want to leave you with today, and this will be recorded for posterity, is that at no time in Irish history has it been more important to encourage, to support those young men and women in their teens, in their 20s, looking towards or maybe interested in a possible career to publicly serve. You've seen many of us talk about our family experiences. You've heard about the harsh realities when history falls on top of a person's time of service. All these family names hold their place in history because they showed up. They put everything on the line, their families as well. One day, history may fall upon you. It may call you to risk everything for a greater good, for the benefit of many. Where will you stand on that day? Gorev Maga.
Erskine, thank you so much for that. I can only describe it as a tour de force. There would be an enormous round of applause if we were here live together, I'm sure. And a paper delivered with such commitment, really from the heart, and conveying the message which all of us associated with this project wish to convey to those who are listening to us and those who come after us. I just need to say to you that there are, Erskine, that there are a serious number of comments coming in here, which can be basically summed up as brilliant, moving, and thank you so much. Very evocative. I can't keep up with them. They're coming in here they're coming in with such speed, but awesome, deeply appreciated. All the adjectives are getting used up. I think the main message of public service for the future is the one which we want to go out from this conference, and that's how you've ended off the paper on your great grandfather and your grandfather. If I may, just come to some of those questions which have come in. Blathna, you'll be pleased to know that you're not excluded from this, from these comments, who've also coming in here saying how much people have really appreciated, listeners, participants have really appreciated the clarity with which you have explained what are in fact very complex issues. And one of the questions I have for you here is, you mentioned that the Statute of Westminster was a critical document, and that the Irish had a very significant part to play in that in that act when it was in the framing of that act and when it was ultimately passed through Westminster. I think, am I right in saying that John A. Costello was actually an author of that act, or the ideas that were contained in that act?
I think you're absolutely correct. He was part of a number of members of the Common and Gael government in the 20s who made outstanding contributions to the rethink and the exploration of legal ideas underpinning Dominion status. And they used their, and people like Kevin O'Higgins, Paddy McGilligan, Desmond Fitzgerald, and in the background, writing the scripts was John Hearn. They really took on a diplomatic and legal role, pinpointing through a series of imperial conferences and sub-conferences, pinpointing what were the legal issues. And this was also taking place within the Dominion framework, where the Dominions were not monolithic. There were different viewpoints coming through. Some were wanting to move much more quickly towards formal statements of independence than others. But alliances used to build up at some of these conferences, and the Irish had good alliances with the Canadians and with the South Africans at different stages. And so absolutely, John A. Costello would have been a pivotal person during that period. John A. was Attorney General at that time, and his influence. But Paddy McGilligan also had an enormous impact, absolutely enormous impact on rethinking of those legal ideas.
So it could be said, could it not, that Ireland was actually responsible for the making of what we now know to be the modern Commonwealth?
Well, it had a lot to do with it. Between that and then the concept of external association, which was De Valera's concept back in, which he enunciated back in August 1921. And the influence of that came later. And in fact, Nicholas Manser was one of the people, the historian Nicholas Manser, who had been involved in some of the British civil service activities during the war and the Commonwealth Office, that sort of experience. And he then had contacts with the people in India. So the Indians actually looked at the draft of De Valera's ideas, and then they put their own twist on it. So an enormous impact on the development of the Dominion and Commonwealth, yes.
I think that was all much confirmed by the decision of the Privy Council in 1935, which confirmed an interpretation, essentially, of the Statute of Westminster, which was, I suppose, illegal from a very high court, and of course, in the Court of Appeal in England, or the Privy Council in England, essentially confirming that actually what this statute meant, was true independence for all of the dominions.
That's right. And I mean, it's one of the ironies that they were speaking very much from the British legal theory version of events. It happened to suit Ireland at that point, but if you were to go back into it, you will, if you're looking at it from the perspective of Irish legal theory, you'd come across line by line and say, no, we don't agree with that, we don't agree with that. But the end result was that they confirmed that legislation of a particular kind could be passed without any restrictions on members of who were able to take advantage of the statute of Westminster. And that benefited Ireland in a funny sort of way. But we would never, I mean, the Irish governments at that time, the last thing they wanted to do was to be relying on an English act passed by an imperial parliament as another passport to their freedom. That was something that was, going right the way back to 1921. That was the last thing they wanted, but it did oil the wheels at the time. That
decision of the Privy Council also recognised that the root of legality, so to speak, for the Irish Constitution was the actual Dáil, not a Statute of Westminster.
They relied very much on the December legislation, and this is why I was saying there's aspects in it which we wouldn't recognise, but they did refer to the role of the Constituent Assembly. So it wasn't as if they hadn't recognised that, but they sort of they emphasised so much the December stuff that really it wasn't a sufficient vindication for Irish legal theorists of a nationalist persuasion.
To what extent do you think that the fact that the 1948, that the fact that we could not remain in the Commonwealth as a republic, in other words, we wanted to be a republic, but as De Valera had always taken the position of external relationship, that as a republic we had to go out, and to what extent was our exit from the Commonwealth as a republic responsible for the 49 declaration, which allowed other dominions who wanted to go there but wanted to stay in? How responsible was it?
I don't think it was really responsible for it. And I think we could have stayed in if we had wanted. At a legal level, we could have stayed in. But of course, at a political level, that's something quite different. De Valera hadn't exited or attempted to formally exit the Commonwealth because he was kind of keeping an eye to its potential benefit vis-a-vis Northern Ireland. But the timing was deeply ironic, 1948, 1949 and all of that. But it really was that after the war, after having gone through all of that, what was happening in Asia with Burma, with Ceylon or Sri Lanka, Pakistan and India, that was what really propelled it forward. And the Indians, they were, Nehru was very happy to stay within the Dominion. He thought, why leave on bad terms? Why not stay? And at that stage, the politicians from the Dominions were saying, oh yes, let them stay, let them stay. India was an enormously important country strategically. They didn't want to lose a country as important as that. And also the whole dynamic of Commonwealth relations had changed by then. It was a Commonwealth. It wasn't an empire any longer. It was rebranded, remarketed, if you like, to use that phrase.
Another question for you, Blathna, and it's this. Do you think that those who spoke with such passion in the treaty debates have really had a thorough understanding of the legal complexities which were thrown up?
Alas, no. I really don't. And I think when you look at it from the unfair vantage point of somebody looking at it 100 years ago, so, clearly it's a whole lot easier sitting in an armchair than to go through it. I think there was a huge amount of confusion that permeated that. I think there was extraordinary emotion. People got up and had their say and explained their feelings and their hurt on both sides. But I don't think they fully understood. A few did, but the debates would suggest that there was a lot of confusion. I mean, one confusion straight up, which is very apparent when you read it, is the confusion as to what were they doing? Were they approving or were they ratifying? Well, they were actually, insofar as they as a Dáil, which was not recognised by the British, they were trying to approve. That was what they were supposed to do under the treaty. But the wording gets totally confused and words like ratification come in. The ratification was supposed to come later. So even that as a small indication shows the confusion. And then there was confusion over the Dominion status. I mean, that was something that the kind of what they were getting from Canada, that was something that was really very unclear to all but a few experts at the time. And they kind of had an idea, but they didn't really understand what it involved. And then you had other issues like the status of the plenipotentiaries and what was the business of the Dáil in relation to entering into an agreement that appeared at one level not to be a republic. To be perfectly honest with you, and I'm saying it to the correct person, you could have spent 10 days or a month in the Supreme Court on that alone. These were highly complex questions, as indeed was what was happening in the Westminster Parliament. The few legal learned judges who expounded their views, very few of the other people took those up because they simply didn't know, and they didn't know if they attempted to do so. They didn't know where the points were going, but none of it was litigated. None of it, other than some of the cases later in the 30s, touched just fractionally on it, but they didn't really understand where they were going.
And I suppose that is actually gains traction when actually one takes the trouble to actually read the debates, that there seemed to have been quite a lot of confusion between the de jure situation in Canada and the de facto, that there were people basically saying, yes, but de facto Canada is what's on offer to us is actually a lot more than what you're saying, depending on. That's right. Here's another question, Blathna. I think this is the last one for you. How important do you think it was that the British conceded this provision in the treaty where tax raising powers and customs were an integral part of the treaty, which in fact had been rejected by Lord George in 1920. So that he had moved clearly from a position of more or less outright rejection, still home rule kind of concept in 1920, to full tax raising and revenue.
I think that was important once you got down to that level. But from my reading of the debates, and I'm not saying this just as a lawyer, although I'm obviously influenced by that, there were four big issues, and everything else was very subsidiary. They were kind of things that they argued about in late October and early November. But the big issues were the oath, Dominion status, Ulster. They were all status type issues. But the other enormous issue, which I think really overwhelmed everything else of a non-strictly legal nature, was defence. That was hugely powerful. And so the tax things were things to disagree about, but they had managed to resolve a lot of that, and they still couldn't get proper agreement on the two sides, from the two sides. But certainly a lack of fiscal authority in your own country, that's a big no-no in terms of sovereignty. And for example, the Dominions would have had much higher levels of control than that.
Do we have any insight as to why the new state, and even in the Articles of Agreement, I don't think there was some possibility of this happening, but the new state did not nominate its representatives to the Council of Ireland, and actually abandoned the High Court of Appeal for the whole of Ireland? It seems a bit of a contradiction in terms. Was this because of the desire to be completely independent and not seen to be using any, if you like, of the mechanisms of the 1920 Act? Or do you have any insight as to why it seems strange today, I suppose, looking back, why perhaps we would love to have a Council of Ireland and a court which would have jurisdiction to make sure that, I suppose, the rights of minorities on both sides of the border would be protected?
I think that really just fell away in the scheme of things. I think from the nationalist point of view, the Government of Ireland Act of 1920 really was, in many ways, was kind of a toxic subject because it was so resented as having imposed partition. But I think also that the relationships in terms of the Council of Ireland and dealing with the North were so fragile at that time that anything that was going to involve difficult, possible cooperation, etc., I think it was just too sensitive at that stage, and it was kind of brushed away. In fact, even as late as 1924, a number of senior politicians showed that they didn't even realise what had happened about the Council of Ireland. And I think that was the reason for it. It was, they had enough to be contending with the Civil War, what was going on in Belfast, etc., and then what was going to happen with Ulster opting out, the period for doing so, etc. So I think it was yet another thing, and put it to one side and leave it.
Even though the Northern Parliament had actually nominated its representatives to sit on the council.
Yeah. I think that it came from the wrong pedigree.
Can I just interject on one point that Blathna raised? I think one of the maybe mistakes Erskine made when he was drafting several documents for DEV, and it's commonly known that Erskine drafted document number 2, but I think the big mistake he made was to, going on Blathna's point, focus on too much on defense and too much on those articles, rather than focusing on how to deal with the minorities in Ulster. There's a fascinating document in Childers' papers it actually says unfinished, or I think it's unfinished is the word that's on the top of the document, but it's called Ulster Power. And many years ago, Dr. Bauman of RTE, well, Dr. Bauman of much bigger than RTE now, but he brought up that point too, that one of the major criticisms towards Erskine and his handling of Ulster was that he brushed it aside to the bigger issues, that, again, defense.
And just on that Erskine, there's a comment in here. The public service is underappreciated. It is hard work and requires persistence and resilience. We can take inspiration from those who, from 1914 onwards, as they continued on and on over multiple obstacles to set up the country, that all sides contributed.
Yes, absolutely.
Yeah,
no question about that. And there's it's interesting, Robert Brennan's book, Allegiance, I highly recommend to everyone who's interested in not only the 20s in Ireland, but in the concept that the treaty basically disintegrated the original Harcourt Street Sinn Féin was disintegrated by the treaty, then put back together. And that evolution, and we're not talking about a long timeline there, we're talking about 2 years or 2.5 years, is extraordinary in itself. And all civil servants in Ireland, public servants too, should look at that in the context of what was happening to these men and women that, as I said in my talk, put everything on the line and showed up. His book Allegiance kind of taps into that. Desmond Ryan's book, Remembering Zion, also taps into that idea that there was a futility to public service in the 1920s.
And follow on from precisely that comment, Erskine. Here's another comment. Erskine, super reflections there. Thank you. It has occurred to me during current work on archives. This is from Niall Murray on archives. And my apologies to the other contributors. I should have mentioned their names. So I do apologize. But Niall posts this. It has occurred to me during current work on archives of rural Dublin and County Cork that this same quandary of how to act in unforeseen dilemmas over loyalty, for example, to the Dáil or to the Crown, faced many officials of public bodies which pledged allegiance to Ireland. While many such roles were taken over by Republican and IRA figures, particularly at national level in the Dáil administration, others were retained by long-standing officials of boards, guardianships, rural and urban district councils who chose to stay in their jobs despite risking arrest. Right. Prosecution, and worse, as a result of serving the emerging republic. And of course, we know some of the judges stayed on as well.
Absolutely,
they stayed at their role, at their place when they were threatened with assassination.
Judge Davitt has an extraordinary set of articles that I've read recently, and again lived right through the Civil War period. But there were many times when he was looking around his, around the corners and behind his back all the time. I mean, I don't think people realize, and now in the age of social media, what it meant to be without the internet and publicly serve and have to deal with security issues. My grandfather, the president, was constantly threatened. I mean, this is on record. It's not something that I'm revealing here. He was an English-speaking, English-born, English-educated president of Ireland, right at the top of the worst of the Troubles. So again, going back to what I was saying, this is the time, especially when you see even further. I mean, we can take it much more recent in the history of this government presently, and how far the abuse goes when they try to publicly serve the best they can. They're all human beings. They're all with their flaws, and they go forward and they do the best job that they can. And what I say to people who, let's say, attack a Taoiseach or attack a Taoiseach is, you sit in their shoes. You sit in their shoes for 1 week, and then think about what you say on the internet about them. And you know this well, Bernard. And look, my mother and father worked for, my mother worked for 35 years in the UN. My father for over 20. I had public service literally all around me. I grew up with public service at the dinner table. Again, you see the public face and the private face. And that is critically important to what I was trying to say in my paper, was that there's a sacrifice made, and we need to honor that sacrifice in order to keep public service in Ireland going, period.
And in a world where actually responsibility duty are not really popular words, especially in a modern generation, trying to get people to actually subscribe to the idea that they can actually do something for others apart
Exactly.
from
Exactly.
themselves. And actually, I think, as I was saying myself at the round table, as what Bob Barton said to me when he was giving me advice was, you would surprise how much pleasure and satisfaction you get out of serving other people.
That's right.
Which was great advice. Going back to you, Blathna, just a comment in here. Fascinating and illuminating presentation from Dr. Ruane. Glad to hear the reference to my predecessor. This is from James Kingston. My predecessor, John Hearn, as a CODA, the Irish Free State government also registered the 1925 amendment to the Articles of Agreement with the League of Nations in 1926. James Kingston, Department of Foreign Affairs. Thank you, Blathna. John Shorten said that he was very upset to hear that those threats have been made to President Childers. And then he said, as a result, so Tim Lynch says, as a result of everything that's happened at this 2 days and over this conference, he said, through this conference, and maybe as a result of something which will come out of this conference, is perhaps honour and duty is still alive in Ireland. The COVID pandemic showed that people in the health service and other public bodies did go beyond the call of duty to help and assist others. And I think that's as good a place as any to finish this session. So thank you both for your wonderful contributions to our project.
We're going to just have a couple closing remarks. I'm going to hand over to Carol Fawcett, and then I'll have a few final remarks after that.
I just want to say thank you, Erskine, for a most interesting conclusion, full of emotion and insight and a call to public service. But on behalf of the descendants of the members of the Irish delegation, I wish to thank President John O'Halloran, Dr. John Borgonovo, Dr. Mervyn O'Driscoll, Gabriel Doherty in the early months, and UCC School of History for hosting this stimulating and informative conference on the first Anglo-Irish Treaty of 1921, also a first in Ireland in this centenary year, and for facilitating our inclusion as descendants in terms of the topics chosen, participation as speakers, chairs, and the Roundtable of Descendants. So we are very grateful for all your endeavours to make this such an inclusive and political conference. Thank you. And I just would like to encourage you all to obtain a copy of the book on the men and women of the Anglo-Irish Treaty delegations when it's launched in January, hopefully 2022. Many of the descendants of the original delegation, as possible, were identified, traced, and asked to assist by providing biographies, memories, documents, and photographs. So their help has been invaluable. And it's hoped that this book will awaken more family memories, leading to further revelations and research. As Erskine said, please check the suitcases in the attic for any information on the historical events of 1921. Thank you, everybody.
We are drawing to a close, to a conclusion. First of all, I'd like to thank Taoiseach Micheál Martin for a remarkable address this morning that wove together the past with the present so effortlessly. It was thoughtful, insightful, and relevant. So thanks to him for opening day 2 with that tour de force. I'd also like to acknowledge our conference patrons for their generous financial assistance, Cork City Council, Cork County Council, and the Department of Tourism, Culture, Arts, Gaeltacht, and Sports and Media. They've been important partners to the School of History, and we're grateful to them, particularly Nikki Carroll, Paul Moynihan, and Connor Nelligan. Thanks also to Deputy Lord Mayor Sean Martin and Cork County Mayor Gillian Coughlin for attending today's proceedings. Thanks, of course, are due to our speakers, Dr. Caoimhe Nic David, Dr. Sinead McCool, Professor Bernadette Whelan, Dr. Michael Kennedy, Professor Chris Williams, Professor Richard Toy, Carol Fawcett, Dr. Robert Lynch, Dr. Ian Dalton, and Dr. Blathna Ruane and Erskine Childers. Their contributions were superb, and they really illuminated the nuances and complexities of a contested subject. Thanks also to Dr. Ida Milne and her wonderful Descendants Roundtables with Anya Broy, Professor Ida Segura, Mr. Justice Bernard Barton, Dr. Ronan Fawcett, and Julita Clancy. We were blessed with strong chairs, Cathal Brua, Dr. Michal Fohertig, Bernard Barton, Dr. Helene O'Keefe, Julita Clancy, Dr. Murvern O'Driscoll, and Ambassador Paul Johnstone. So thanks to them. The conference would not have been possible without the descendants of the Dáil Treaty Delegation Family Group. The event began as their initiative, and they were key to its success. I want to particularly thank three of the group leaders, Carol Fawcett, Richard Fawcett, and Julita Clancy. We look forward to reading their forthcoming volume on the full treaty delegation, which will be released early next year. Thanks to the 400 or so folks who turned in throughout the weekend, and especially to those who contributed questions. Here at University College Cork, a number of people made this event happen. First, we'd like to thank President John O'Halloran for his opening remarks this morning and for his support of the event. Thanks also to his team in the President's office, especially Dr. Niamh Connolly. Special thanks goes to Donna O'Driscoll and her team in the Office of Marketing and Communications. They were tremendous in their promotion and organization of this conference. Thanks to Owen Hassey, Joe Leob, Terrell Cullen, and Denise Goggin, who helped get us over the line. The team at the conference office at UCC were their normal, highly efficient and highly effective selves. Special thanks are due to Jean O'Callaghan. This is my second conference I've run with Jean, and I cannot compliment or exaggerate her organizing skills enough. Thanks also to Michael and his colleagues from CABS for broadcasting us today. Here in the School of History, the conference was co-organized with Gabriel Doherty and our head of school, Dr. Murvern O'Driscoll. Thanks to both of them for their assistance throughout the long process that culminated in yesterday and today's proceedings. This conference is the first in UCC's Civil War program, coming from the College of Arts, Celtic Studies, and Social Science. Here at UCC, we enjoy remarkable expertise in the study of Revolutionary Ireland. But we also make a point of collaborating with other scholars and institutions, and in making our scholarship accessible through public engagement. In the coming months, we will be producing special editions of the Irish Examiner, digital humanities projects with RTE and the Military Archives, a new Truce and Civil War update of Andy Bielenberg and Jim Donnelly's Cork Fatality Index, and a 3-part documentary on the Irish Civil War in partnership with RTE. We are especially excited to host the National Conference for the Irish Civil War, on the Irish Civil War, which will be a 4-day event hosted by UCC from June 15th to the 18th. That will include a robust public program, which we hope will contribute to improving our understanding of this contested but still relevant conflict. We hope to see you in June on the lovely grounds of University College Cork to tackle the topic of the Irish Civil War. In the meantime, thanks for watching. Slán.